Welcome to the second module, Capacity, Legally Authorized Surrogate, and Best Interest. An overview provided by the New York State Justice Center for the Protection of People with Special Needs, Surrogate Decision-Making Committee, or SDMC. During this presentation, we will provide an overview of three decisions: capacity, legally authorized surrogate, and best interest. There are three decisions that the volunteer panel members must make, always in this order, beginning with capacity, then legally authorized surrogate, and ultimately, best interests. Volunteer panel members begin with the question, does this person have the capacity to make this decision? People are presumed to have capacity unless proven otherwise. Then the panel members gather information to rule out the presence of legally authorized surrogate who is available and willing to make the decision on this person's behalf. If there is no surrogate identified, panel members will determine whether the procedure is in the person's best interest. Let's discuss the first decision, capacity, in greater detail, which is the most important decision. First and foremost, the volunteer panel members must decide whether the individual can make the decision for themselves. And if they can, panel members need to respect their decision to make their own choices, and the individual would not need SDMC to provide consent. The preferred decision maker is always the individual. All patients before the committee have already had a formal capacity evaluation completed by a psychologist or psychiatrist, which is part of the declaration packet submitted to SDMC. Volunteer panel members review this record prior to the hearing and establish the findings on the record during the hearing. The lack of ability to consent applies only to the medical treatment decision before the SDMC at this time. It does not generalize to other procedures, future treatments, or other legal proceedings. There are several factors to explore when determining capacity before taking away someone's ability to make their own treatment decision. Volunteer panel members need to consider communication, understanding, appreciation, and reasoning behind the decision. Some of the questions that need to be asked can include: can the individual communicate a choice? Is this person able to demonstrate an understanding of the rationale for the procedure? Why is the physician recommending it? Can this person appreciate the risks and benefits of the recommended procedure? And if so, can the person articulate the reasoning behind their decision? The three elements of capacity are knowledge, intelligence, and voluntariness. Knowledge. The patient cannot make a decision without information. The procedure must be explained in order to make a competent decision. Preferably, this has been done by the declarant or the nurse using language and terms that the individual understands. Knowledge can be obtained by providing information to the patient. The SDMC declaration requires that the patient have the procedure explained. If it hasn't been explained prior to the hearing, providers will offer an explanation at the hearing. Another way to gain knowledge is by experience. The panel may ask the individual what the procedure was like for them if they had it performed previously. The previous experience may affect his or her capacity to make the decision the next time the procedure is recommended. The second part of evaluating the patient's capacity is intelligence. Volunteer panel members can consider the following questions. Can the individual demonstrate an understanding of the proposed treatment in relation to his or her medical needs and compare options and likely outcomes with and without treatment? Can the patient repeat all the information in their own words? This allows the volunteer panel members to assess the patient's retention of needed information and capacity to integrate that information to arrive at a logically consistent decision, whether the same as the providers or not. The patient might have an option which should be considered. The third element of capacity is voluntariness. A competent decision cannot be the result of an interfering factor, which results in the person being unable to exercise free will, such as coercion, duress, denial, panic or fear, anxiety, or delusional thinking. For example, a patient might make a certain decision because they've been promised a special privilege if they agree, or that they will have a privilege removed if they do not. SDMC needs to make sure that the individual makes a decision without outside influence. Capacity is evaluated every time the person comes before the committee. SDMC can't take the person's capacity away for one procedure and then say that because they didn't understand this procedure, they can't understand any procedures. Capacity decisions should be applied only to the specific treatment or procedure that is under consideration. SDMC regulatory guidelines identify the need to determine whether or not the patient can understand the burden of treatment, appreciation of pain with and without treatment, understand the prognosis, and the evaluation of treatment options. Some sample questions can include: can the individual understand the prognosis? If there is a tumor which may be cancerous, what is the likely outcome or prognosis with and without treatment? Does the patient understand that the surgery or treatment could be approached different ways? Can they evaluate treatment options and demonstrate a rationale for their choice? If the individual can understand the burden of treatment, appreciates the pain associated with and without treatment, understands the prognosis and treatment options, then the volunteer panel members may determine that the individual has capacity to make this decision. If the patient cannot explain their rationale to have the procedure or treatment, or not to have the procedure or treatment, can be evidence of their lack of capacity. A patient can make any decision he or she wishes if it is done with full appreciation and acceptance of the consequences of that decision. The question is whether they can explain why they made that choice. For example, a patient who previously had always provided her own medical consent came to the SDMC for a decision due to the risks involved in a recommended spinal surgery. Her residential agency brought the case to SDMC because of the high risk associated with the procedure. The patient was diagnosed with a tumor on her cervical spine, which caused significant pain in her neck and would likely impair her mobility if it were not removed. The patient was able to articulate that she really wanted the surgery to relieve her pain, and that she understood that if the surgery wasn't successful, she might never walk again. She expressed that her pain was severe and she felt the benefits outweighed the risks. The patient was able to articulate the reasoning behind her decision and demonstrate an understanding of the risks, benefits, and burden of treatment. In this case, the panel granted capacity and the patient made the decision to have the procedure. The legal standard for the panel to consider when determining capacity is referred to as clear and convincing. Clear and convincing evidence is evidence that is highly reliable and upon which reasonable persons may rely with confidence in the probability of its correctness. The evidence must be clear enough such that each volunteer panel member is convinced that the person is incapacitated prior to voting no to the question of whether the person has capacity to make the treatment decision. Both the law and regulations require at least 3 votes by the panel that the patient does not have capacity to make the decision. Again, capacity is presumed. It is up to the panel to vote as to whether the person lacks capacity, essentially to take it away by voting no. If the panel does not have 3 votes, the person has capacity. In order to better understand capacity, let's discuss 3 case examples. The first case example involves a patient who was given the diagnosis of breast cancer. As information about a recommended mastectomy and treatment options were explained, she was unable to comprehend any of the information due to an overwhelming sense of panic. The psychiatrist evaluated the patient's capacity and provided a detailed explanation of the extreme panic that the patient was experiencing, which prevented her from making a capacitated decision. He testified that the patient's extreme anxiety was interfering with her ability to hear and properly assess the information. She had a hopeless attitude, and it made her unable to actually hear and consider the risks and benefits. Therefore, the volunteer panel members agreed regarding her lack of capacity and that the mastectomy was in the person's best interests. The next case example involves a woman with a mild intellectual disability who was refusing a cesarean section for delivery. It was discovered at the hearing that the procedure and also the rationale had not been fully explained to the patient. When the volunteer panel members asked who had explained why the cesarean was recommended, the patient indicated that no one had explained why. The volunteer panel members contacted the physician by speakerphone, and the physician explained that she needed a cesarean rather than a natural childbirth because of a particular spinal issue which presented a significant risk to a safe delivery, and that this could present a risk to her life as well as the life of her unborn child. This explanation and information allowed the patient to demonstrate that she did want to have the procedure and that she now understood the risks and benefits of the proposed cesarean section. The panel determined that the patient had capacity to make her own decision to have the cesarean section. Understanding of the risks and benefits of treatment versus non-treatment is an important concept when determining capacity. In this example, the patient receiving dialysis expressed at the hearing that he didn't want to keep going to dialysis because it took too much time and was unpleasant. This individual didn't understand that if he didn't continue with dialysis, he would become very sick and potentially die. This patient needed to have the risks and benefits of treatment and non-treatment explained. Once that was provided, the patient understood why dialysis was needed and was able to make a decision to continue treatment. The panel determined that the patient demonstrated he had the information necessary to express a capacitated decision to continue dialysis. Once the capacity issue has been fully evaluated at the hearing, the panel chair will make a distinct transition to the issue of surrogacy. The volunteer panel members must rule out that there is not someone who is better suited, is more familiar, or legally authorized to make the decision on the behalf of this person. For individuals receiving services through the Office for People with Developmental Disabilities, New York State regulations recognize a hierarchy of decision makers authorized to make major medical treatment decisions for individuals who are not able to make their own medical decisions. This hierarchy, created by OPWDD, defines actively involved as significant and ongoing involvement in a person's life so as to have sufficient knowledge of the person's needs. In order to determine a legally authorized surrogate for individuals served by OPWDD, the agency must first determine if there is a lawfully empowered guardian or healthcare proxy. If not, is there an actively involved spouse? If not, then moving down the list, determine if there is an actively involved parent, then an actively involved adult child, an actively involved adult sibling, or an actively involved adult family member. For Willowbrook class individuals, a Consumer Advisory Board, or CAB, provides consent on behalf of those individuals that are fully represented. As you can see, SDMC makes the decision only when there is no other available and willing decision maker. For individuals under the jurisdiction of Office of Mental Health, or OMH, or Office of Alcohol and Substance Abuse Services, or OASAS, a spouse, parent, adult child of the person, or a court of competent jurisdiction may make these decisions on behalf of those patients who lack the capacity to make their own decisions and who do not object to the treatment. There is no hierarchy and no requirement for active involvement. Of particular note, siblings are not included on the list of legally authorized surrogate decision makers. Sometimes the patient may have a person that we refer to as a correspondent. A correspondent is someone who is supportive and familiar with the person's needs. They may not have the legal authority to make the decision, but they have meaningful information about this patient and their best interests. SDMC wants to include correspondents as interested parties in the hearing process. The correspondent receives notice of the hearing and is encouraged to attend because they are part of this person's life and have a lot to offer with regard to decision making about this person's needs and best interests. Correspondents can include a friend in the community, a family care provider, or a community advocate. A correspondent could also be a family member who could legally be a decision maker, but has requested not to make the decision. For example, an individual may have an actively involved sibling, but that sibling might not want the responsibility of making medical decisions and would like to attend the hearing as a correspondent. Again, correspondents know the individual well, provide support, and are familiar with the individual's needs. There are special requirements for a healthcare proxy or HCP that is completed for an individual residing in an OPWDD program. If the healthcare proxy was properly executed according to OPWDD regulations and the person is determined to lack capacity, the healthcare agent makes the medical decisions. However, SDMC may be able to consider the case if the healthcare agent waives the right to make the decision, is unavailable, or doesn't respond to attempts to contact them for the informed consent. In some cases, even if someone has executed a healthcare proxy, SDMC may still consider the case if the agent is unavailable or perhaps has lost touch with the individual. If someone has a legally appointed guardian with the authority to make medical decisions, the case would not move forward to SDMC. However, if the guardian is not available and there is no other family member or healthcare agent to make the decision, then SDMC may accept the case. This is, of course, something that would be thoroughly evaluated as SDMC is processing the declaration. The case would also have documentation to explain the reasons the guardian is not making the decision. The legal standard for the panel to consider when determining whether there is a surrogate to make the decision is the same clear and convincing standard applied to determining capacity. As stated earlier, clear and convincing evidence is evidence that is highly reliable and upon which reasonable persons may rely with confidence in the probability of its correctness. For surrogacy, it is evidence that leaves you with a firm belief or conviction that it is highly probable that the person does not have a legally authorized surrogate that is available and willing to make the decision. Both the law and regulations require at least 3 votes by the panel that the patient does not have a legally authorized surrogate available and willing to make the decision. Once the capacity issue has been fully evaluated at the hearing, the volunteer panel members will make a distinct transition to the issue of surrogacy. The volunteer panel members must rule out that there is not someone who is better suited or is more familiar or legally authorized to make the decision on the behalf of this person. In this example, the healthcare agent was unavailable. A patient with a properly executed healthcare proxy was hospitalized and in urgent need of a gallbladder removal. This person had properly executed a healthcare proxy, however, the residential provider and physician were unable to reach the healthcare agent because he was out of the country for an extended vacation. This case came to SDMC and the hearing was held at the hospital and included testimony from the provider concerning the attempts to reach the healthcare agent with no response, and testimony from the physician regarding the need for an expedited decision. In this instance, SDMC was able to step in and provide informed consent in the absence of the healthcare agent. When the healthcare agent returned, he resumed the responsibility for making healthcare decisions. The third and final decision the panel must make during the hearing is whether the procedure is in the patient's best interests. Your decision as a volunteer panel member is made as if you were standing in that patient's shoes with consideration of that person's individual circumstances and quality of life with regard to the decision. We call this substituted decision making. Best interest is promoting the personal well-being by the assessment of the risks, benefits, and alternatives of a proposed major medical treatment by taking into account the relief of suffering, preservation or restoration of functioning, improved quality of life, the individual's quality of life with and without treatment, and personal beliefs and values held by the individual. Panel members are making this best interest decision for the patient with all of these considerations of the individualized factors and unique needs. A certain procedure or treatment may be beneficial for one person, but that doesn't mean it will have the same impact or the same risks and benefits for another person. The patient's opinion regarding the proposed major medical treatment is to be given full consideration by the volunteer panel members and balanced against the best interest needs of the patient, as well as his or her ability to understand and appreciate the consequences of his or her preferences. A hallmark of SDMC's inclusiveness is the respect for autonomy. Volunteer panel members should be aware if the patient has a previously stated preference or opinion about the treatment. The panel is not bound by the person's opinion or preferences. However, the panel needs to balance the best interests of the patient against those stated preferences when making this determination. Things to consider when determining best interests can include: how important is it to move forward with the treatment over their objection? Do we have the ability to move forward in cases where people are incapacitated and objecting to treatment? The question brings us back to capacity. Is this person refusing the treatment in a capacitated manner? However, in many cases, individuals with intellectual disabilities, particularly persons diagnosed with profound intellectual disability, there may be no bias upon which to determine what the patient would have wanted. Quite often, SDMC doesn't have this information if the individual is not able to communicate verbally. You may need to rely more on the documentary evidence and testimony from providers in terms of what this person would likely choose. Best interest decisions must consider the burden of treatment and level of pain. The burden of treatment concerns whether the pain and suffering outweighs the benefits or whether the proposed treatment would merely prolong the patient's suffering and not provide any benefit. Members need to consider if the patient's condition will not improve, nor will the prognosis be different if they undergo this burdensome treatment. Therefore, how will this affect the patient's quality of life? The level of pain includes the degree, expected duration, and the constancy of pain with and without treatment, and the possibility that the pain could be lessened by less intrusive forms of medical treatment, which can include the administration of medications. Will having the procedure result in diminishing or eliminating the pain or discomfort currently being experienced? Or would there be greater benefit to treating the pain with less intrusive methods and letting nature take its course? Best interest decisions must also consider the prognosis and treatment alternatives. The likely prognosis, expectant level of functioning, degree of humiliation and dependency, with or without the proposed major medical treatment, needs to be considered. Things to consider can include: what will the impact be on this person's level of independence? Will there be a restoration of functioning? Will the treatment offer the patient a greater chance for recovery? Will they be restored to a previous level of functioning, such as improved sight or restored ability to ambulate or increased independence? Will this individual have to be restrained or restricted in any way in order to tolerate or accept the treatment? Treatment alternatives include the evaluation of treatment options, including non-treatment and their benefits and risks compared to those of the proposed major medical treatment. What is the effect on prognosis? If the risks of an optional treatment are less, why choose a riskier procedure? Is there potential for greater benefit? The legal standard for best interest is fair preponderance of the evidence, which is evidence that when weighed for its quality rather than quantity, that tips the scale to give consent or withhold consent for the proposed procedure or treatment. The patient's opinion of the proposed major medical treatment is to be given full consideration by the panel, balanced against the best interests of the patient, as well as his or her ability to understand and appreciate the consequences of his or her preferences. Volunteer panel members should consider the person's preferences, but also be mindful that doing so should not risk the person's life or health. Both the law and regulations require at least 3 votes by the panel that the procedure is in the patient's best interest. In order to better understand best interests, let's discuss 2 case examples. A previous case involving a woman with a severe intellectual disability who was diagnosed with breast cancer. She often expressed discomfort behaviorally and was often self-abusive. There were 2 options recommended for her treatment: a lumpectomy with radiation daily for 6 weeks, or a mastectomy. The lumpectomy, a removal of a portion of the breast tissue with the cancer, was less invasive than a mastectomy, removal of the breast. However, the lumpectomy would have to be paired with 6 weeks of daily radiation treatment. This would require the patient to be positioned alone for radiation treatment, in which she would have to remain perfectly still for 15 minutes. It would be unlikely that she would be able to comply with the radiation treatment. The physician recommended the mastectomy, the more invasive procedure, because the lumpectomy will have a longer length of post-surgical treatment, which the patient may not be able to tolerate or comply with. During the best interest portion of the hearing, the panel considered the treatment options, risks, and benefits, including how the patient would tolerate the burden of treatment of radiation versus a mastectomy. They learned that the patient was unlikely to comply with post-lumpectomy radiation and that she would tolerate the mastectomy and recovery much easier than ongoing treatment. Therefore, the panel determined that the mastectomy, the surgery with a shorter recovery period in the long term, was in the patient's best interest. Another example of determining best interest involves the impact on the patient's residential placement. When weighing the risks versus the benefits for the treatment, such as placement of a feeding tube, a tracheostomy, or permanent reliance on mechanical ventilation, it's reasonable to consider the impact on the patient's residential placement. Things to consider can include: will the patient be able to return home with familiar people caring for him or her, or will this require a placement in a more medically skilled environment? How will this person respond? SDMC heard a case involving a patient who had been weaned off the mechanical ventilator and discharged back to his residence in a very fragile condition. He didn't have an order in place to withhold CPR if he was found without a heartbeat or respirations, and his prognosis was very grim. He would likely have another medical event, and if placed on a ventilator again, it was unlikely that he would ever be successfully weaned off the ventilator. The natural progression of his chronic medical condition was that his heart and lungs would fail and he would eventually require mechanical ventilation to sustain his life. This would require a transfer to a skilled nursing care facility, and he would never be able to return to his residence of 20 years with his familiar caregivers. His provider expressed at the SDMC hearing that this individual was highly sensitive to lights and sounds, and the environment of a skilled nursing center, with the monitors and the alarms in that setting, would have a tremendous impact on his comfort level and adaptation. He also had difficulty with new staff people and would have a very difficult experience with the rotating staff and shifts of the skilled nursing facility. Given this information, the panel determined that it would be in the person's best interest to be allowed to pass away naturally at home when his disease progressed, surrounded by the people who had cared for him in this familiar setting. The panel approved a do not resuscitate or DNR and do not intubate or DNI decision. If you have any questions about the SDMC process, please call 518-549-0328 or email sdmc@justicecenter.ny.gov. The Justice Center maintains a distinct toll-free information referral or INR line, which is 1-800-624-4143, 8:30 a.m. to 4:30 p.m. Monday through Friday. Staff responds to calls and email inquiries regarding disability issues, including disability rights, legal assistance, housing, employment, assistive technology or AT, healthcare, and any other disability-related questions. Specifically, staff connects individuals with information, provides technical assistance and/or referrals to programs or services, and solves problems for individuals with disabilities, parents and guardians, advocates, employers, and providers. For more information about the Justice Center, please visit the website at www.justicecenter.ny.gov.